Okay, so good afternoon, everybody, and welcome to Bolt Burdon Kemp's webinar series focusing on Cauda Equina Syndrome, or CES to use its abbreviated term. Cauda Equina Syndrome is a rare but life-changing condition where the spinal nerves at the tail end of the spinal cord are compressed. Those who suffer with CES can be left with impaired mobility, impacted bowel, bladder, and sexual function, as well as pain and ongoing challenges to their mental health. Indeed, CES is a condition which impacts everyone very differently and therefore poses different challenges to different people, as we heard in our session last week. Before we get started, please kindly note that this session is being recorded and your cameras and microphones have been turned off. You are still able to ask questions, and we would encourage you to do so. This can be done via the chat function. We may ask some of the questions as the webinar is going along, and we may save some of them until the end. October is home to Cauda Equina awareness, and we are looking forward to using this month to really spotlight the impact CES has on people and those around them. In today's session, we are looking at disability benefits, mainly PIP, and the challenges faced, especially for those with CES. And I am delighted to be joined by Jane Nelson. She is the perfect speaker for this topic and has a wealth of experience in the area. She is a welfare benefits caseworker in Birmingham and has a speciality in disability benefits appeals. She also works at or assists at Birmingham City University Law Department, training law students with regards to PIP appeals and providing advice on benefits. In addition to these roles, she is also a consultant with Paladin, who are an independent financial advisory service. It gives me great pleasure to hand over to Jane to talk you through this important topic. So over to you, Jane.
Hi, thank you for that, Rhiannon. And thank you for the glowing introduction. Yes, I have several years, nearly 40 years, that sounds awful, doesn't it? Experience in welfare benefits. It doesn't mean a thing because things change all the time. I will touch on some of the proposed changes that the government were planning to make on the disability benefits, but they seem to have railed back on some of those. So it's a little bit in the air at the moment, but obviously very concerning for my clients and presumably your clients as well, who are in receipt of disability benefits. I had the great pleasure of addressing the Cauda Equina Syndrome conference last year in Watford, that some of you may have attended, and I did a presentation there as well. So, and I put my hands up. I was just saying to Rhiannon, prior to being asked to do that, I had very little, if no knowledge at all on Cauda Equina. But I have recently, which I will mention later on in the presentation, I've recently been successful at an appeal, a PIP appeal for one of my clients who has Cauda Equina. And again, I was lucky to I'm in touch with someone from the Cauda Equina champions, whose name completely escapes me, sorry, up in Clitheroe, and we do talk on occasion if I have a client with Cauda Equina. Once I've heard about it, I've met more people, not just clients, but people in meetings, colleagues, and you realise that although it is quite rare, I seem to have met more people recently. Maybe I've become just more aware of it, I suppose. As Rhiannon said, what I'm hoping to cover today is mainly PIP, which is a working age benefit for people with disabilities, physical, mental or cognitive, for those aged between 16 and state pension age, which is a movable feast at the moment, around 66.5. I'm also going to mention DLA for children from birth to 16, and also attendance allowance, which is a pensioner benefit. for disabilities if no previous claim for PIP has been made. Okay, can I have the next slide, please? Just a little bit. I've been with Paladin. I quite like the thought of being a consultant. I'm a kind of freelance their welfare benefits expert, if you like. I've been involved since January 2024, and it's been an eye-opener and very, very interesting work. And I think, as Rhiannon said, there's two sides to Paladin. There's the kind of financial investment side, and then there's the kind of expert side where people attend court to talk about losses following an accident, for example. I'm the person who comes in and does a benefit assessment on somebody because, again, as you're probably aware, if any compensation or damages are within a personal injury trust, it doesn't impact on either on a means tested benefit such as universal credit or pension credit, or obviously the benefits we're talking about today, which are non-means tested. So PIP, attendance allowance and DLA. In the main, there are times, of course, when it may be counted, but very rarely. And certainly capital does not impact on a claim or an award of disability benefits. Thank you. So what we're going to talk about today is what they're called several things. It can be called non-means, non-contributory benefits, circumstance benefits, or need-based benefits. So the ones I'm going to talk about today are, as I said, PIP, DLA, attendance allowance, and they are non-means tested benefits. There are other kind of eligibility criteria in addition to the disability that the person has, but I will talk about that in a short while. It's for claimants who need assistance with personal care as a child or somebody of working age. Also can be awarded an amount of money for mobility issues. I'm afraid once you put in a claim for attendance allowance, which is a pensioner benefit, for the first time, once you become a pensioner, there's no mobility element. So I did a PIP application last week only. On the Wednesday, I ordered and registered this gentleman's PIP to be sent a PIP application form last Wednesday, and he became a pensioner on Friday because his main disabling condition was mobility issues. And as long as you have registered that PIP application by phoning PIP and giving the details and finding out whether people are eligible, so the immigration status, residential care issues and things like that. Once you've done that, it doesn't matter if the form is sent out after he became a pensioner. He will still be assessed under PIP rules, not attendance allowance rules, which don't offer that mobility. It's a really useful tip to know that it's when you phone to claim and register your PIP claim that counts, not when you put the claim in. Okay, thank you. So again, I've mentioned these benefits. I'll just say a little, I'm going to go into DLA in more detail. Again, I do apologise if I just throw acronyms out like DLA, and if I go to a housing meeting or I don't know, a community care meeting, I sit there and I think, what are people talking about? Because they're talking about in DLA and PIP or the equivalent in housing, and I think, please say the full thing. So I've got to get used to doing that. So it's disability living allowance from birth in some cases to just before your 16th birthday for a child. But there are some people that you may come across who are still on DLA, okay? Because when PIP came in April 2013, if you were on DLA which was the previous benefit that ran from birth to pension age, and then attendance allowance followed that. PIP came in and kind of took over the working age chunk in the middle in 2013 April. So it took over from 16 to pension age. However, if you had attained pension age or attained the age of 65 on the date the PIP came in, which was in April, I think it was April the 6th, 2013, you remained on DLA. Okay, so you may come across people and you think, hang on a minute, they're 77, why are they on DLA? It's because they're long-term claimants who were there before 2013. But now there's no new claims for those people. The only new claims for DLA are from birth, if the child is born and is terminally ill, so has been given kind of less than 12 months to live. If they haven't been given a terminal illness diagnosis, you can claim for that baby from the age of 3 months. So it's still a very young age. I'm going to say a little bit more about DLA shortly. PIP, as we've said, is from 16 to pension age. A DLA claimant, a child claimant, will be invited to claim PIP as they approach their 16th birthday. So 15 and a half, 15 3/4, they will be invited. When you're invited to claim, when you sent an invitation, there is the idea that you can decline. There isn't in this. So if you don't complete a PIP claim, then your DLA will stop. And as we'll see later, with DLA, PIP, or any of these benefits, it's not just the DLA or PIP or attendance allowance physically that you get. It's the knock-on effect. It's the benefits your parents might get for you. It's the benefits you might get for yourself, or the extra benefit. So if that DLA stops for a child because you haven't completed the PIP form that you've been sent, then disabled child premiums may stop and other things such as that. It's not just the DLA. So once you're on PIP, however, as you approach pension age, you remain on PIP. Okay, so you could be, you could meet a 77-year-old who is on PIP because they've been on PIP since before, since 2013, they've reached pension age, they continue on PIP. So you could meet 3 different pensioners, one on DLA, one on PIP, one on attendance allowance. And you've got to realise all these are mutually exclusive benefits, which is a posh word of saying you can only get one of these at the same time. So if you were to meet somebody in their 70s and say, oh, you want attendance allowance? And they go, no, never heard of that. Oh, I'll help you claim it. And then you start claiming it and they go, but I'm on that PIP. And then you realise that you can't claim them both at the same time. Attendance allowance is for those over pension age when they first claim. Like my mum, I claimed it for once I had power of attorney because she wouldn't claim it before that. And she's now on attendance allowance because she never claimed it before because she was okay. She only developed dementia in her 80s, and then and it goes that little bit towards, because she's a self-funder, it goes towards her care home fees because she's allowed to retain her attendance allowance within a care home because she's a self-funder. You see, once you go into any form of residential care, if you are funding yourself, you can keep these benefits. If you are funded by the local authority, or the NHS, you will lose the care side. Retain the mobility side, but lose the care side. So again, that's something to think about. AFIP, or Armed Forces Independence Payment, I've never met anybody or helped anybody on this. This will be done in-house within the armed services, and it's for somebody who's been injured whilst serving service personnel. It doesn't have to be in war. It could be a car accident or tank overturns, I don't know, on a Salisbury plane or something. As long as they are injured and they are serving service person, it will be handled in-house. It's better for a service personnel to be on AFIP because they automatically, if they qualify, get the highest rate of both equivalent, and it doesn't stop when you're in hospital long term. So it's much better if people qualify for AFIP to get that rather than PIP, for example. Okay, next one. So again, I think I've done all that. I think I've done that one actually, Rhiannon. So I was 8th of the 4th, 48. So it must have come in on the 9th. So PIP came in on the 9th of it, or 3 days out, on the 9th of April, 2013. So you can see if somebody was born on or before the 8th of April, so they're already 65 in 2013, they remain on DLA. Okay, thank you. So just a little bit about DLA. DLA for children, I've said from birth, if they are terminally ill. But the other thing is you can't claim or renew any of these benefits if you're in hospital, okay? You can put a forward claim in. So I'll mention somebody, one of my clients, when we talk about PIP, whose PIP ran out when he was under section, and the issues, the problems it is causing. Nobody's fault, but because he's now about to be moved over to universal credit and he's not on DL, he's not on PIP at the moment. So I'll talk about that in a short while. For DLA, there's 3 levels. It's the only one that has 3 levels. We'll see with PIP and attendance allowance, there's only 2 which equate to the middle and high rate. There's no low rate. Even though confusingly, attendance allowance calls the middle rate low rate, but it's the middle rate. So there's no low rate as such on PIP and attendance allowance. There's only DLA has these 3 levels and 2 levels of mobility, which PIP also has. But remember, attendance allowance has none of that. Okay. So for DLA, for the care component, during the day is frequent attention in connection to their bodily functions or continual supervision throughout the day in order to avoid substantial danger to themselves or others. Very difficult to get this, as you can imagine, for a child. When do you have to give more supervision to a young child? So you have to argue over and above the supervision or care or watching over that you would give to any child of a certain age. During the night is prolonged or repeated attention in connection with their bodily function. Prolonged is more than 20 minutes and repeated is more than once. So it doesn't have to be both. So you may go in twice during the night, each time for 20 minutes, but that you don't have to do that. It's either or during the night, or requires another person to be awake for a prolonged period or frequent intervals for the purpose of watching over them. And then part-time daycare requires attention from another person for a significant portion of the day. That's up to an hour a day, which doesn't sound like a lot, but it's an hour. That could be 15 minutes here, 15 minutes there, 15 minutes here or there. And I've mentioned these because depending on which one of these you fit into, that depends which level of DLA care you're likely to get and how to argue it. Okay. So for the highest rate of care, the child must satisfy one or both of the day and night conditions. So they need help during the day and night, or they're terminally ill. And for benefits parlance, that is, you are reasonably expected to die from a progressive illness within 12 months. It's increased from 6 months a few years ago. It's now 12 months because it was acknowledged that that 6 months didn't bring other terminal illnesses into account. It just really was for people with cancer, for example. So they extended it to 12 months. The middle rate of care, 1, either the day or the night condition. So not both, that would be middle rate care. And the lowest rate of care, it's that frequent help for up to an hour a day. Okay. And I should say a little bit about the age of the child. We've said from birth if they're terminally ill, from 3 months if they are if they've got a disability but they're not thankfully terminally ill. But for mobility, obviously we don't pay mobility from birth because none of us can walk from birth. So it's from the age of 3 or 5. So from the age of 3, it's a physical disability. And from the age of 5, it is a, maybe you can walk, but you may have a cognitive issue or autism or epilepsy or something like that where you can actually walk. Now, it is frighteningly difficult to get. Interestingly, I've just had something through from a Paladin source about trying to increase it for a child, for a 9-year-old child. It's very, very difficult to argue that you can get the highest rate of mobility if you can walk. It's not impossible, but it's difficult. Normally, you have to fit into one of these. You're unable to walk, okay, straightforward. You're virtually unable. The excursion would constitute a danger to life or lead to a serious deterioration in health. No legs or feet from birth or amputation. Serious visual impairment. There's a particular level. You don't have to be completely blind. They are deaf and blind, but this is the one we tend to use, is number 7. The first thing you have to have is highest rate care component. If you don't have highest rate care component, it's a non-starter. So you have to be in receipt of highest rate care. And so I get a lot of people of my clients with children with autism, for example, who are on middle rate care, low rate mobility. So the argument is to try and get them onto highest rate care first. That's the first step. But then other people are on highest rate care and they still argue that they're on low rate mobility. I've got 2 cases at the moment, one Paladin, one work, where we're trying to get 2 children, one with an acquired brain injury, one severe learning disabilities, up from the lowest rate care on these grounds. Severely mentally impaired with extremely disruptive and dangerous behavioural problems. Again, it's all set out in the regulations, exactly what you need. Somebody from the DLA department, very helpful person. You'll find there are helpful people within there. There are unhelpful people, there's also helpful people. Sent me a link and said, have a look at this. It's a really straightforward one. It's written for parents. If you can tick every one of these boxes, then there's a chance we can look at highest rate mobility. If you can't tick every one of these boxes, you can't get it. So it's a difficult one, but not impossible. Okay. Next one, please. So I'm going to move on to PIP now. I'll talk a little bit at the end about the claim for DLA for children and how that impacts on a parent's benefit as well. So to get PIP, either you have, if you're claiming for the first time, you've got to be age 16 to reach the state retirement age. You satisfy the daily living, which is the equivalent of care. It's called daily living under PIP, and or mobilities activities for 3 months prior to the claim, and you need it for at least 9 months. So you're talking a minimum of a 12 month. You can't break your leg and claim PIP. I was in A&E with my broken ankle 3 years ago, and I saw this poor lad who was about my son's age, about 22 or something, and he was hobbling around with this awful looking, awful leg. And I ended up sitting next to him and saying, it was February, and saying, what happened? And he said, football injury. It was bloody hell. And I said, when did you do it? He said, last September. I was kicking around in the park with my mates. I wasn't even playing football properly. And of course, my initial thoughts, I didn't say it because I'm not really an ambulance chaser, claim PIP, because he'd already, so September, October, November, December, January, February, he'd already had it 5 months, and he had no idea when he was going to be well enough to be able to walk around without pain. But I thought, I can't accost somebody in the waiting room of A&E, so I didn't. I have been known to do it in the past. If you are terminally ill, this is waived. Okay. If you've been given a terminal illness diagnosis, you can claim immediately. You need a form called an SR1, which is called a Special Rules Form 1, which will be provided by your medical person. That could be a doctor, it could be an oncologist, it could be a nurse, it doesn't matter. And that will just confirm by the DWP seeing an SR1 form, they know you are terminally ill. They won't ever say on that form, this person will die within 12 months. They won't say that, but they may say this person has got stage 4 breast cancer, for example. And then the DWP will know, seeing that the person is terminally ill. This only helps, by the way, with your care. I think the next slide may cover that, or one of the subsequent slides. I've got one on on the special rules. No, it must be the one after. I said earlier that you don't just get it because you've got a disability. So you've got to pass the presence and residence test. You've got to be here for 2 out of the last 3 years, 104 out of 156 weeks. So if I come back, and that doesn't matter whether you're a British passport or anything. If I've been living in Australia for the last 5 years and I come back because I want to live in the UK, I'm riddled with arthritis, I satisfy the conditions for PIP, I won't get it. I'll have to wait for 2 years, okay, before I can claim. So unless I'm terminally ill, then I'm exempt. Okay. You've got to pass the habitual residence test. Again, this is a benefits test which doesn't exempt British nationals, and you have to show that you are habitually resident in the UK. But that kind of cancels each other out. The first and the second one, because if I've been here for 2 years, then I can argue I'm habitually resident. But that only came in with the introduction of PIP. It was never there before that. But then they extended it to attendance allowance and DLA as well. Not be subject to immigration control. Okay, so if a wife has come to join her husband, she's perfectly well, she's on year 2 of a 5-year visa, she's involved in a car accident, awfully kind of affected by that, she won't be able to claim PIP, even though she's been here for 2 years, because she's not got indefinite leave. And if you saw the Labour Party conference at the weekend, they're talking about extending that from 5 to 10 years. So that will impact a lot on certain migrant communities in the UK. Members of the armed forces who live abroad are exempt, because if you're on a base in Germany, that is Crown territory, it's the same as being here. Same if you're a diplomat, as soon as you walk into that embassy, you're on British soil. So again, they will be exempt from that. There are EU Social Security coordination rules, which all my students go, I have to do EU law, it's so boring. And I think it's great. I think it's really fascinating. And I'd like to go back to uni and do EU law. It's very complicated, but essentially, if you come across a client who's maybe lived abroad within the EU, they've lived in France for the last 10 years, and they return to the UK due to sickness, due to illness, due to developing something like Cauda Equina, they come back to the UK. It's not a no that they have to, it's not a given that they have to wait 2 years. It depends why they were in France, what they were doing in France, were they working in France? And in some circumstances, the time spent in France can be used for the time here. So again, it's just ensuring that anybody who approaches you, who spent any time within the EU, we need to know exactly what they were doing. Because essentially, if you've lived and worked there, and contributed to the French system, then the chances are you may be able to use that time spent. If you've retired and moved to Benidorm or whatever, then you won't be able to use it. But it's far more complicated than that. But Just ask more questions if you come across a client who has spent any time within the EU. On occasion, they will make concessions. The last ones they made were Ukraine. So they'd say somebody can come to the UK, they drop immigration rules, they drop benefits rules. And so somebody comes in from the Ukraine who's been injured or is sick, then they don't have to qualify for those 2 years. And they'll do it every now and again. They may do it from flashpoints in the Middle East, for example, or Sierra Leone or Hong Kong or whatever. So it's just keeping an eye on things like that. Okay, thank you. So how do we claim it? We phone up that first number, 0800. This first phone call, and you have to do this by phone. You can't, I say you have to do it by phone. You can do it on paper, but it tends to delay the claim. So the point of this first phone call, this is the one I did with my client last week, is to register the claim, for them to find out whether he's been here for 2 years, for them to find out what his nationality is, what his immigration status is, has he been in hospital, is he in hospital or care home? And it's kind of the non-disability questions to see whether or not, my concern, of course, is that will somebody on the call centre for PIP know the nuances of EU social security coordination rules? So if somebody said, I've just come back from France, will they know to ask the right questions? I doubt it. But, you know, that is my fear. Probably doesn't happen. I'm just a bit geeky, sorry. So yeah, so that is the main. They will also ask, one of the questions they also ask, which is interesting, is are you in receipt of a pension from another EU country? Okay, that doesn't need to be a disability pension. It could be an old age pension, a disability pension. If you are in receipt of something like that from another EU country, that stops you from getting a disability benefit here. Because the argument will be, sorry, you paid into the community in Latvia. I'm thinking of a client of mine who was on attendance allowance. They did a trawl and realised that she was getting some pension. It was minimal, 30 quid a week from Latvia, but that stopped her from getting attendance allowance here. So her attendance allowance stopped, but because she'd reported it and said it on the original claim form, there was no overpayment. Attendance allowance unit informed me at the time there was 20,000 people facing there was thousands of people, sorry, facing an average overpayment of £20,000 because they do these trawls every now and again. Okay, now that doesn't matter. There was no equivalent. I even looked into whether there was an equivalent disability pension in Latvia. There wasn't. It doesn't matter. It doesn't matter. And she could give up that pension, still wouldn't matter. Okay. It's all part of the quirky nature of, again, of what makes European law so interesting. So that's the sort of questions they'll ask you. The only disability question they will ask you on that form is, do you have some form of memory issue? Dementia, for example. Do you have some form of cognitive or learning disability? Now, they ask this question not to make a value judgment on you, even though clients think it is, and it's not. It's for the client's benefit in the widest meaning of the term, in the fact that if they find out that you have got a memory issue, for example, if you haven't sent they will make a note of that. And if you haven't sent your form back on time, they will think, wait a minute, Jane said that, you know, she had a memory issue. We'll give her a gentle reminder, or we'll give her a little bit more time because she's said to us she's got this issue. Okay, so it works in the client's favour if they fit into one of those categories. So if you are helping somebody with that form, then it's not something to trip them up. It's something to actually assist them and make sure that the claim isn't closed because they haven't responded by a specific date. So you can claim online. I find it easier, but I've got several email addresses from, sounds like a bit dodgy, but it's not. I've got several email addresses and I've used most of them now, claiming for clients online. Okay. And you can only use that one email once. So if they haven't got an email or they prefer me to do the filling in of the form, then it's so much better. You can do the form, bang, it goes in, you know that it's there, okay? And you can download it and keep a copy. It's just so much more straightforward. But obviously some people, like the chap last week said, oh no, I said, I've run out of email addresses. He said, I'd rather come into you and do it on paper. I said, fine. So we asked them to send a paper copy out. So that's fine. So they'll send that paper copy to you. But if you're computer savvy and the client is happy to do that sort of thing and fill it in, then I would always recommend online. Okay. So here's the special rules. So the reason be expected to die within 12 months, that gives you an automatic entitlement to the highest rate of PIP or DLA, care, or attendance allowance, with no more questions asked. You tick the box at the beginning of the form, you provide the SR1 form from your doctor or your consultant, and that's fine. But they'll still ask you questions about mobility. So somebody I helped, oh gosh, it's a number of years ago now, and she had a very active job. We've got these little shopping centres around South Birmingham in about 4 different areas, and she managed them. So she used to race all day around these different shopping centres and walk, 4 or 5 miles a day. So when she was diagnosed with cancer, before it became terminal, and she said to me, Jane, I used to walk 5 miles a day. Now I'm lucky to be able to walk from my house to Sainsbury's. Now, it wasn't across the road. Sainsbury's was probably about a mile each way. But for her, that was reduced mobility, absolutely. But if you can walk 200 meters, you're not going to get PIP mobility, and I think people don't realize how low the bar is or how high the bar is, to be able to argue physical disability on PIP. It's 50 to 200 meters, you'll get 4 points and you need 8. So it's breaking down clients' expectations or when things change. So, under the old rules, you could do it. There was no meters, so, or you got more points for walking less time, and they change things. Things change over the years, and people are impacted and don't realise. And that's our job, to come in and help them navigate through this complex system, really. And you need that SR1 form. It used to be called a DS 1500. It changed to SR1 a couple of years ago, because I suppose it makes more sense when you think it's called the special rules. It's very British, special rules, I think. We don't actually say it as it is. Special rules. If you see a special rules, I've had people going, it's great, Jane, I've got my PIP straight away, and you realise that they're under special rules and they don't know. So, okay. So what do we need? This is when I'm going to come in and talk about my clients that we won a PIP appeal only about a month ago. So these are the areas. If you don't, and we have to fit into these areas, okay? So as you can see straight away, all the things that people will talk to you about, oh, I can't do my shopping, I can't do my laundry, I can't iron, I can't garden. All these things that people find really difficult. It doesn't matter, because it's not a bodily function, okay? And it's the same with DLA and attendance allowance. if you have problems with shopping, why do you have problems with shopping? Can we relate it to any of these? If you can't bend down to pull out a weed out of your garden, why can't you bend down? And if you can't bend down to pull out a weed in your garden, you're not going to be able to bend down necessarily to wash your feet in the shower. And this is what we have to do, because it's so much less, I wouldn't say humiliating, but maybe embarrassing for people to say, I can't prune my roses anymore, than I can't lift my hand up to wash my hair. So we have to kind of think creatively about how we fit them into this without making them embarrassed or making them worried. So these are the areas. Preparation of food. Okay, this is preparation of food for a single person, and it's a main meal, a simple meal, but a main meal. It's not a sandwich. It's not a soup. They did introduce with PIP microwave meals. If you can put it in a microwave, but you can't cook, you will get points for that. But it is really a piece of meat, a piece of fish, some tofu, rice, cooking on the hob, putting in the oven for one person. So if it's a single parent with 3 kids, they're not bothered about, in the nicest possible way, they're not bothered about that woman or man cooking for the kids. They're bothered about you, and if you can cook a main meal. And so that's kind of chopping, slicing, boiling vegetables, stirring soup. So that could be a physical issue. You might have a perching stool in the kitchen, or it could be a mental health, that you haven't got the motivation to cook, or it could be a learning disability, for example. You don't realise how long to leave the chicken in the oven, or you let the food burn because you've got dementia and you forget it's on. It can be one of those things. So I've lost the slideshow. Yeah.
Yes, I know. I'm trying to get it back up. Bear with me.
It's okay, I can carry on talking. Don't worry. It doesn't. So yeah, it's it's cooking, taking nutrition. So again, that could be physically eating, or having the motivation to eat, or having to have some sort of peg feed or something to eat. It could, and then the next one is taking medication. Do you know how to take your medication? Do you know when to take it? Do you forget to take it? Do you take too much? Do you have a Dissect box? Things like that. Then it's washing and bathing. Again, motivation and physical. Do you have a seat in the bath, etc., etc. Going to the bathroom. Do you have a raised toilet seat? Do you have a rail by the toilet? Do you have something to help you clean yourself afterwards, or someone to help you clean yourself? Then dressing, communication, reading. And that's not reading, it's reading in your own language. So you can't say, I don't read English. They'll say that's not a disability, unless there is a reason for that. Okay. Dyslexia, we can argue. And the last 2 are engaging socially with other people, mixing with others, and making decisions about money. Okay. And then the mobility components are going out, which is also known as planning and following journeys. That is, again, a mental health, a cognitive issue, for example, and moving around is your physical issue. So I just wanted to talk a little bit about my client, who's fabulous. He's lovely. He's got various disabilities, one of which is Cauda Equina. Took a long time to diagnose, and this was all before I met him. So when I met him, he'd been found completely fit for work for universal credit, and he'd been given 2 points for PIP. We'll see in a minute, you need 8 points, between 8 and 11 to get the standard rate, and 12 and above to get the enhanced or higher rate for both of these 2. You can add within their living and add within mobility, but you can't add across the 2. So this gentleman had 2 points for toileting, and nothing else. No points for any of these. No points for mobility at all. So we went to court. We explained about all the issues he had, you know, the terrible issues he had with toileting, obviously self-catheterizers. He said, well, we've given you 2 points for that. The problem he has getting in and out of the bath because of his both the pain and the numbness, the seat in the bath, the little stool that he steps on because it's just a traditional council maisonette in Birmingham. So there's no walk-in shower. He showers above the bath. The fact it's impacted on his mental health, so he doesn't go out much. He just wears the tracky bottoms if he's and a t-shirt if he's in the house. He's 62, and he's got no motivation to eat. He used to cook really nice meals from his culture that he doesn't now, so he just survives on pot noodles and those noodles that you add boiling water to. First time I went to visit him, he had no food. I went to Tesco's and did him a shop because he had no food in the house, because he can't get out. We didn't put anything in from budgeting because, as he said to me, Jane, I got no money. How can I budget? You know, because I'm on £400 a month universal credit. And reading that he was fine. He asked me to go to his doctors because he was on a lot of cocodamol, and the doctor had stopped his cocodamol. And so I went to the doctors with him, and the doctor said, you know why I've stopped these? Because I don't want you to become dependent on them. And so I've kind of stopped them for the time being. It's better to get used to a little pain, he said, than a long-term addiction. I don't know what I think about that, but I mean, he seemed to be doing it for the right reasons. Anyway, we went to court, and he ended up with 14 points for each. Okay, so he got 14 points for daily living, and he got 14 points for mobility. I just brought up while I was waiting for the one to start about what we asked for, and we asked for preparation of food. We asked for taking nutrition because he neglects himself, he's lost weight. We asked for the medication. We asked for washing and bathing, dressing and undressing. We did ask for communication because he's got really bad tinnitus and he has a white noise hearing aid, and they gave points for that. Engaging with other people because he doesn't want to go out anymore. He's too embarrassed. He's also very worried about Cauda Equina. He worries about being in a wheelchair, having no one to look after him because he lives on his own. And we ended up with points for moving around, which was 20 to 50 meters, which was 10 points. And they also gave us 4 points because he's lost any confidence in able to go to an unfamiliar place. So he ended up having the enhanced of both. So he's ended up with £797 a month, and a back date of £12,000. But he shouldn't have to go to court for that. It was absolutely clear that he should have got that. We're going in, we haven't got a date yet. Hopefully this side of Christmas, we're going for his universal credit, to argue that he's not fit to work and he should get extra money on his universal credit. But it's hard when I ended up putting a lot about Cauda Equina in the submission I did to explain what it was, because there's only one doctor on the panel. There's a judge who's legally qualified. There's a disability qualified member who knows about disabilities because they work with people or they are disabled themselves. But there's only one medical doctor, so who again may not have heard of it themselves. So I think if you are doing anything further than the initial form, I don't think it does any harm to do like a belt and braces. You know, just put a lot of information about Cauda Equina, what it is, how it impacts. Problem with my client, he's got severe sciatica and Cauda Equina, so we're trying to kind of sort out the fact that he had numbness and pain, which was really difficult. But enough of him. He's a lovely man. I'm so pleased, and he's going to go on holiday, which first time for 20 years he'll have been able to go on holiday. So this is the figures. So remember, this doesn't impact on anything. It doesn't impact on work. You can work and get this. It doesn't impact on any of the benefits, your universal credit, your pension credit, your ESA, employment support allowance. So standard rate is 8 to 11, £73.90. Enhanced, 110.40 a week. It's payable 4 weekly. And the same for mobility. 8 to 11 gets you 29.20, and enhanced gets you £77.05. You can choose to use that to lease a car, which I'm sure you're aware of under the Motability Scheme, where the £77.05 goes towards a car, and that covers your tax, your national insurance, your tax, your insurance, your MOT, all of that. It's all covered. Literally all you have to do is to fill it up with petrol. So when they're looking at those descriptors, this is what you have to look at. Can they do this safely? Can they do it acceptably, repeatedly, and timely? So can my client walk 50 metres or 100 metres? Yeah, he may be able to walk 100 metres. Can he do it again? Probably not. Can he do it? I could do 100 metres in bottom of my road, I don't know, 2 minutes. It might take him 10 minutes. And if it takes him more than twice as long as somebody without a disability, that is not timely. Can you do it acceptably? Can somebody with dementia or somebody with limited vision, should we say? And when my granny's vision started going off a little bit, I noticed she'd have a jumper on with, you know, a bit of gravy down the front because she couldn't see, and she'd have been appalled. But that's not acceptable. Would you go out dressed for the weather if you had a learning disability? And can you do it safely? Could my mother cook before she went into the care home? God help us, no, because she would have left the gas on, she would have burnt things and everything else. So she couldn't do it safely. So that's what you have to look at when you're looking at the forms. It's not, they might be able to do it once, but not again. And that's called the reliability test. Okay. They also look at, I'll send the descriptors through to Rhiannon, and then people can have them. It's really useful. I have the descriptors with me all the time, which is not all the time, obviously, not on a Saturday night, but when I'm at work, I have the descriptors with me all the time, and I have this wonderful book, which you can't see, called the Disability Rights Handbook, produced by Disability Rights UK, which is such a good book to have. It's got all the descriptors in, all the points next to it. So I'll just pick one out that may be applicable to Cauda Equina. Managing toilet needs. You can manage it, or incontinence, 0 points. Yeah, an aid or appliance, 2 points. Supervision or prompting, 2 points. Assistance, 4 points. Assistance to be able to manage incontinence of the bladder or bowel, 6 points. And of both bladder and bowel, 8 points. Okay, so I said that to show you what these mean. So supervision is a continuous presence of another person for the purpose of ensuring the claimant's safety. I don't know, I always use my own son in this. He was diagnosed with epilepsy when he was 14, 15, perfectly okay now, fortunately, on medication 12 years later. But obviously at 15, I wouldn't be saying, I'm going to come and sit in the bathroom with you while you have a shower or bath. But what I would say to him would be, don't lock the bathroom door. Don't have a shower or bath when I'm not in the house or your dad's not in the house. I'm downstairs. And that is supervision. So it's being around the person. It might be standing in the door of the kitchen going, maybe it's worth turning the potatoes off now. But it's not physically getting involved. Prompting is a reminder. That's more the mental health, learning disability, dementia. Come on, mum, have you changed your clothes? Have you taken your medication today? Have you eaten today? And that could be done on the phone as well. Okay. And assistance is your physical intervention. Getting somebody out the bath, helping them dry the hair, helping them put the shoes and socks on because they can't bend anymore. And you'll see with assistance that you get more points because obviously it's more help. Okay. But again, I can send through the descriptors because it's really useful looking at them, especially if you are helping someone fill a form in or you are helping them to challenge a decision. So they obviously fill the form in, they send it off to the DWP. The DWP then arrange Capita to do a healthcare assessment, either on the phone, face-to-face, on video. You can take somebody with you. You can request a recording and a transcript. I sit in on quite a few of these on the phone. I went in with somebody to the office in Birmingham in July. It lasted 2 hours. It was horrendous. And they gave her less points than they had. We went to appeal and she'd got worse. She got 6 points. So we were missing 2 points. And the judge, she kept saying, I've got worse, I've got worse, I've got worse. And which I told her not to say. And if you've got worse since the decision, it can't be taken into account because the DWP can't look into the future. They can't see that you've got worse. They can only look at you at the time that they made their decision, even if it was a year ago and you had a stroke 6 months later, you can't take that stroke into account. The only thing they will say is claim again. So the judge said, claim again. I think if you claimed again, you'll probably be successful this time, Miss X. So we claimed again. I filled the form in, shows how good I am. I filled the form in, went the assessment with her, and they gave her less points than they did when we went to the appeal. They gave her 2 points instead of 6. It was absolutely crazy. So we are obviously challenging that. There's no rhyme nor reason to this, by the way. It's who you get as a healthcare assessor, who you get as a judge. You know, it's very random, which I find very, very difficult. I find benefits that are, if you satisfy that condition, you get it far easier. So there's a big drive to have them face-to-face more over the next few months. I think that's better, but I also acknowledge that some of my clients do not want to go. It's not into a hospital, it's just a building, it's an assessment centre, right in the middle of Birmingham in our case. It's not massively intimidating, but then again, it's not me going through it, is it? So, but okay, next one. Obviously, you get the decision back and you're either happy with it, which is great, or you're not happy with it. You could be happy with one level. You could have been given high rate mobility and no daily living or standard daily living. You can ask for it again, but a caveat to that is whenever you challenge a decision, they will look at the whole award. You can say, and some judges are lovely at appeal, say, look, we're happy with that part of the award, but we'd just like you to look at this part. But they can at any stage, at mandatory reconsideration stage or appeal stage, choose to look at the whole award. If you think you've got worse and you put in the appeal, you put in a new claim or ask them to, the bottom of the PIP form, it'll say, you have to inform us if you've got better or if you've got worse. Nobody reads the first line. If you've got worse, you've got to tell us, okay? So my client who had, that sounds awful, mental health issues, OCD, various other things, we got him the standard rate of both. And then he had a massive stroke. We won the appeal. We couldn't use the stroke. We reclaimed after we'd won an appeal, told them about the stroke. It went through it all again, and they took everything away that they'd already given him. So even though he was already getting PIP, they took it away. They'd won an appeal. So now we're waiting for another appeal to get it in back. So he's lost £400 or £500 a month. And it's horrendous. It's actually worse to have it and lose it, I think, than to not have it in the first place, because then you don't know what you're missing, if you see what I mean. So you used to, but you can phone up and ask for an MR, a mandatory consideration over the phone. You used to be able to do it in a letter. I think you should still be able to, but what they're saying now, they want their official form, CRMR1 form. Why? Because AI is looking at it. And AI can't understand the letter. They can only understand the CRMR1 form. I don't know how widespread that is now. That was certainly the case I heard a few months ago. So I use the form anyway with the students because it's very prescriptive. They can fill it in. Ideally, do it within a month of the letter, but up to 13 months. Ignore everything on any DWP letters that say you have got to get back to us within a month. It's wrong. They want you to get back within a month, and it's better to get back within a month. However, you've got ultimately an additional 12 months with good cause. There's no list of good cause. It could be, I couldn't get an appointment at the law centre. I couldn't get an appointment at the CAB. I was in hospital. I was abroad. My daughter was ill. Doesn't matter. And 99.99% of times the DWP say fine. If they don't, you can go straight to appeal. So, don't think that, but why would somebody know that? I want to do a research project into this because why would somebody know 5 months after the decision when it says on the letter 1 month that they can still do it, unless they come in randomly to a law centre or somewhere and they see somebody who says, look, you've still got time. So just be aware of that you can do it up to 13 months later. Obviously, the nearer you get to the original date, the better. But yeah, you can do that. It'll ask on the CRMR1 form, it'll say, are you doing this within a month? If not, why not? And that's when you give your reasons. Set out which descriptions have been met, attach any additional evidence. There's a kind of different ideas within the welfare rights community about how much time you should spend on an MR. MRs were only introduced in 2013. Before that, you went straight to appeal. And we definitely feel it's in there to put people off. Okay. So on one hand, I can say in the last few years that they've been overturned on MR. They prefer to bat it off to an independent tribunal. So, I wouldn't say don't spend any time, but don't kind of beat yourself up about spending loads of time doing a mandatory reconsideration, because they very, very rarely change the decision of one of the colleagues. Again, if the MR is refused, which it is 90% of the time, then appeal within a month. Again, I would suggest doing it online because it's there. You get the confirmation within minutes of that it's been received, but you can still download a hard copy if people off doc.gov.uk if people prefer that. If you've got a representative, fantastic, but a lot of people don't have representation. I go to appeal all the time, and I very rarely see anybody with a representative apart from us, okay, or one of our students. So a representative doesn't have to say a lot. People are scared about putting themselves down as a representative, and they don't need to be, because all the questions really are addressed at the client. Because I can't say what pain she's in. I can't say what impact this has on her life. This has got to be from the person themselves. I was in appeal last week. What was it? The 30th of September, and my client collapsed in court and with a severe panic attack. And instead of going, which I thought they might do, okay, we'll award her PIP. It's obvious she's got mental health issues and panic attacks. They just said, we'll adjourn it. She'll have to come back and do it all again. We're 2 hours into the second appeal. Okay. And she's got to do it all again. But we're going to do it from our house next time on video. So oral hearing is always better. That can be video, telephone, or face-to-face. In Birmingham, it's the worst possible place. The courtroom, if anybody knows Birmingham, Birmingham Civil Justice Centre. It's right on a tram track, so you can't park a taxi outside it. So the first thing they will say is, "How did you get here today, Miss X? How far can you walk?" You know, I mean, crazy place to hold a disability appeal tribunal. Coventry is 20 feet from the front door. So always go, in my opinion, for an oral hearing, because you can go for paper hearing, but then that doesn't give the client any opportunity to give their side of the story in addition to the paperwork. They may as well just look at the appeal bundle, and 40% of those appeals are successful. It goes up to around 80. It's 80 to 90% success rate generally, not just us, when we go to appeal in person. If we need an interpreter, we have to book one, be it a language or sign language interpreter. We can't use our own students or family members. In very, very rare occasions, they may allow it. It's happened to me once where they've allowed it, a family member to be used, when the interpreter had to rush off because his daughter was ill at school. But in general, for obvious reasons, I did one last year with a Polish client, a Polish student, and a Polish interpreter. And the Polish client couldn't understand the Polish interpreter because she spoke very, very high Polish, or very, very, don't know what the best word is, you know, kind of, apart from posh Polish maybe. And he hadn't got a clue what she was talking about because he got quite severe mental health issues. And in the end, the judge allowed my student, who was bilingual, to interpret for him on his level. So it is possible, but you'll have to put on the form, and please put on the form what dialect it is, because there's 120, I found out the other day, dialects of Arabic. And if you've got an interpreter from Morocco and your client's from Syria, I don't know, they might not necessarily be able to understand each other. So always put Spanish, European, Portuguese, Brazilian, you know, just put the actual dialect as well. And access arrangements, that's a difficult one because, like I say, in Birmingham, all the courtrooms are on the second floor and above. So if one of my clients was claustrophobic, and I just had to shove him into the lift in the nicest possible way and say, "Close your eyes till we get to the fourth floor," because if not, I needed him there because it was a physical disability. There's no way in Birmingham of having it on the ground floor. Moving on, impact of a PIP claim or a DLA claim, by the way. Tax credits is kind of a moot point now. There's not really anybody left on tax credits. They should have moved over to universal credit. But when tax credits existed, you could get extra elements for a child who was disabled, a dependent child, depending on the level of PIP or DLA. And you could also get an element on working tax credit if your partner was on a certain level of PIP or DLA. So it's really, really useful. Universal credit, there's disability. I was only teaching this to the students yesterday, in fact. You get a higher or lower disabled child element. And the difference is 156.11 for a lower rate and £495.87 approximately for higher disabled child. It's huge, £340 difference. And to get the higher one, you have to get high rate care, DLA or PIP, enhanced daily living. If you get that for the daily living or care side, and your parents are on universal credit, you get this extra 495 in addition to that 110.40 DLA. Okay, 495 a month, I hasten to add. Universal credits payable on a monthly basis. Anything under that, so middle rate care, low rate care, standard, mobility doesn't really matter for that. You get the 156. So if you do a review when you go up, or you win an appeal, and you win an appeal for somebody, everybody's talking about the DLA they're going to get or the PIP they're going to get, and they should be thinking about everything else. You know, oh, that's more money on my UC, that's more money on my pension credit, more money on ESA, etc. Again, on pension credit now, there's elements for children payable within that because child tax credit's gone. Severe disability premium. This is a stage I should really mention my client who was in under section for 2 years, and while he was in under section, his PIP expired. PIP said they sent the renewal form to the ward, but it was never received. And so he came out in May, and he they realised, his mum realised he wasn't getting PIP. And so the elements that he would have got, particularly severe disability, if you live on your own, nobody's getting carer's allowance, and you're getting PIP at the PIP at the daily living, DLA at the middle rate or higher rate of care, any level of attendance allowance, you get this. It's worth £83.30 a week. It's a huge amount of money. And this young lad, I say young lad, he's 30, he is now out, but his PIP hasn't been sorted, and they want to move him to universal credit. He's got till the 16th of December to move. And we don't want him to move yet because his ESA, employment and support allowance, does not include all the elements that it would include were he to be getting his PIP. So we're trying to push PIP, and kind of, we don't have to do anything with UC because we've got another 2 months. But because if he moves over now, he moves over on this level and he doesn't get any transitional protection. If he moves over once his PIP's in payment and with this extra money on his ESA, he goes over at a high amount with a transitional payment. So if there's anything in the background, you get 3 months to move to universal credit. If there's nothing in the background, they're getting everything, all the money they can, etc. Just get it done and move over to universal credit. Everybody's going to have to do it. But if there is something in the background like this young man, then it's better to get all the money in place before we move. Mention Motability, vehicle tax, enhanced mobility gives you 100% vehicle tax exemption, standard rate gives you 50%, free passes on public transport, carer's allowance for carer if you're getting the requisite amount of, but remember carer's allowance then impacts on the severe disability premium, but you're going to end up with nothing, with no SDP unless you're a pensioner, because there's no SDP on universal credit. They abolished it. And a really important one, if you've got any clients who are renting, okay, so if you are, if my son was still living here now, I've basically just moved out, got the empty nest. So if myself and my husband were on certain benefits and renting our place, his income, my son's income, would have been taken into account, and he would have been expected to pay us X amount of money that would be deducted from either my housing benefit or my housing costs from universal credit. Okay, and it's much better on universal credit. It's £93.2p or something like that a month. Doesn't matter. I could have Erling Haaland living with me on 500,000 a week, and he'd still only have to pay me 91. Make sure he paid me more than that. £91, £93.2 a week deducted. Okay, but under housing benefit, it depends on your earnings, and it can go up to about £120 a week. So it could wipe out somebody's housing benefit. But if me or my husband were in receipt of DLA or PIP or attendance allowance, there is no non-dependent deduction. Okay, it just goes. So if I win somebody a PIP appeal, I will also be contacting Birmingham City Council and saying all that money you took off them before you paid their housing benefit, you need to pay it them back. Okay. So that's one that not a lot of people are aware of. But it's a really, really important one, you know, to maximise somebody's income. And there's more people, there's more adult kids living with their parents now than there ever were. So maybe I should be pleased he's moved out. Anyway, next one. And I think this is a penultimate slide you'll be delighted to know. So carer's allowance, again, a carer must care for the disabled person for 35 hours a week, be over 16, not in full-time education, and not earning over 196 a week. That was increased last year by the current government, 16 hours at the minimum wage, essentially. It was £151 last year. You may have seen a lot of issues about carers allowance on the news, driven by I'm a bit of a fangirl of Patrick Butler, who was the social affairs editor for The Guardian. And he did a big thing about carers allowance and the cliff face. So you would think, so we know it's worth £83.30 a week. You would think that if I earn 200 a week, my carers allowance would go down to, I don't know, £79.30. Absolutely not. For every pound, so if you go over £196 a week, you lose all of this. Okay, you lose all your carers allowance. So you had a lot of people, informal carers, who were saving the government millions of pounds a year in care home fees for 83. Well, you do the math. 35 hours, £83 a week. And it's still there. That's why they increased this here. The acknowledgement that, you know, somebody could do a small part-time job when the child was at school, or when mum was in respite, or whatever, you know, for their own mental health, if nothing else. So you've got to be quite careful about that 190. If you've got countable expenses, if you're a carer and you can, you can count laundry of your uniform or petrol or work boots or something like that. If there's things you can knock off, so you're earning 210, but you can knock off 30 quid of that, that's fine. But it's better, in my opinion, to just stick to the 196 or below. So you can claim the 8330. They must be getting those levels of the only one you need to worry about is PIP. Sorry, DLA, because remember there's those 3 levels. So if they're on lowest level of care, you can't get a carer's allowance. It's got to be middle or higher. But then any level of PIP day living, any level of AFIP, any level of attendance allowance. If you get carer's allowance, it'll come off pound for pound off both universal credit, or if you saw an ESA or pension credit, it'll come off pound for pound. But to compensate for that, they give you what's called, on those legacy benefits, which is ESA and pension credit mainly, they'll give you £46 a week, 46.40 carer premium on that. And that's 201.68 on universal credit. Universal credit, you don't have to physically get carers allowance. You can just say, I'm a carer, I'm looking after this person for 35 hours a week. They will pay that 201.68 as a carer on the carer's premium, which might avoid what we're talking about on the previous slide about people earning too much. So, I mean, that's worth thinking about. I personally think it's better for people to get carers allowance, because I've seen universal credit go wrong too many times. And if people get carers allowance, they've got a pot of money outside universal credit. It also gives you credits towards national insurance, credits towards the future pension, because the acknowledgement that people on carers allowance aren't necessarily going to be able to work full time or can't. So there's a couple of other things on there, but don't worry about it. Slight differences between legacy benefits, and you'll see about how they treat somebody if you're not getting carers allowance, but don't worry about it. We can help. I forgot to do this one when I did this a few months ago, but yes. So you can do the top one, don't do the middle one. Email the inquiries one. That's me in the middle. That's my personal telephone number, so I might not answer it if I don't know. And that's our
Brilliant
website. So
thank you
there we
so
go. 22 minutes. Anything you can.
Thank you so much, Jane. I mean, I think the advice from today has to be to seek specialist advice.
It shouldn't
And
be, should it? It shouldn't
if you're
be.
unsure, and it may be possible to appeal, and ensure that if you are making that application, is to put as much information forward by way of explanation or details, especially for those people with Cauda Equina, because the nature of the condition is that it may not be well known to the people undertaking
Absolutely.
those assessments. Perfect. Well, that brings us to the end of today's webinar. Thank you very much once again, Jane, for your time. It will have been invaluable to those that have been listening. For those that have been listening, please join us next week for our session with Jane Stambridge on bladder and bowels. Thank you once again, everybody, and have a good afternoon. Thank you. Bye-bye. Okay, so good afternoon, everybody, and welcome to Bolt Burdon Kemp's webinar series focusing on Cauda Equina Syndrome, or CES to use its abbreviated term. Cauda Equina Syndrome is a rare but life-changing condition where the spinal nerves at the tail end of the spinal cord are compressed. Those who suffer with CES can be left with impaired mobility, impacted bowel, bladder, and sexual function, as well as pain and ongoing challenges to their mental health. Indeed, CES is a condition which impacts everyone very differently and therefore poses different challenges to different people, as we heard in our session last week. Before we get started, please kindly note that this session is being recorded and your cameras and microphones have been turned off. You are still able to ask questions, and we would encourage you to do so. This can be done via the chat function. We may ask some of the questions as the webinar is going along, and we may save some of them until the end. October is home to Cauda Equina awareness, and we are looking forward to using this month to really spotlight the impact CES has on people and those around them. In today's session, we are looking at disability benefits, mainly PIP, and the challenges faced, especially for those with CES. And I am delighted to be joined by Jane Nelson. She is the perfect speaker for this topic and has a wealth of experience in the area. She is a welfare benefits caseworker in Birmingham and has a speciality in disability benefits appeals. She also works at or assists at Birmingham City University Law Department, training law students with regards to PIP appeals and providing advice on benefits. In addition to these roles, she is also a consultant with Paladin, who are an independent financial advisory service. It gives me great pleasure to hand over to Jane to talk you through this important topic. So over to you, Jane.
Hi, thank you for that, Rhiannon. And thank you for the glowing introduction. Yes, I have several years, nearly 40 years, that sounds awful, doesn't it? Experience in welfare benefits. It doesn't mean a thing because things change all the time. I will touch on some of the proposed changes that the government were planning to make on the disability benefits, but they seem to have railed back on some of those. So it's a little bit in the air at the moment, but obviously very concerning for my clients and presumably your clients as well, who are in receipt of disability benefits. I had the great pleasure of addressing the Cauda Equina Syndrome conference last year in Watford that some of you may have attended, and I did a presentation there as well. So, and I put my hands up. I was just saying to Rhiannon, prior to being asked to do that, I had very little, if no knowledge at all on Cauda Equina. But I have recently, which I will mention later on in the presentation, I've recently been successful at an appeal, a PIP appeal for one of my clients who has Cauda Equina. And again, I was lucky to kind of, I'm in touch with someone from the Cauda Equina champions, whose name completely escapes me, sorry, up in Clitheroe, and we do talk on occasion, if I have a client with Cauda Equina. Once I've heard about it, I've met more people, not just clients, but people in meetings, colleagues, and you realise that although it is quite rare, I seem to have met more people recently. Maybe I've become just more aware of it, I suppose. As Rhiannon said, what I'm hoping to cover today is mainly PIP, which is a working age benefit for people with disabilities, physical, mental, or cognitive, for those aged between 16 and state pension age, which is a movable feast at the moment, around 66 and a half. I'm also going to mention DLA for children from birth to 16, and also attendance allowance, which is a pensioner benefit for disabilities if no previous claim for PIP has been made. Okay, can I have the next slide, please? Just a little bit